over, because there's a lawsuit between St. Louis, the city government is suing because of their wells, and that is still in the courts. And
right, and that's the contamination like broke through the clay wall, or
yeah, I mean, in a way, I mean, we know somehow the contamination is into the aquifer where they get water. You know, I think no one really knows how it, you know, it got there. I mean, one is clearly movement through the clay, you know, the clay wall around. What I believe, and I'm not the geologist, so I don't know, but what I think most people believe is somehow are going through the bottom, which never had a wall or never had it didn't have a liner, and so
kind of hard to under the entire thing.
Right. So one of the community complaints is that in 1982, when this was made to, and then they built the containment system in the early 80s, sort of finished in 84, there was a requirement that if you created a hazardous waste landfill, you had to put in, they call it a double liner, which would be sort of like a plastic membrane, and they didn't do that, and so there's some argument between the community and some people in the community and the state and federal government that they should have forced that to be built.
Right, and that was the people who have to do that. Is that government, or was that actually Velsicol?
Well, you're right there. I mean, you know, it's this. There's this dual responsibility. I mean, the company produced the contaminants. I mean, they produced the product. They sold it. They made money off it. In fact, a huge amount of money off it. You know, and then, but EPA and the state were the ones who reached the agreement with them. So in that sense, EPA and the state are responsible. But admittedly, and we don't like to lose sight of the fact that one who's really responsible is the company. But then the company, because of the buying and selling of the assets of the overall company, the company that exists today is a very small version of the overall company that did this stuff. You know?
Yeah, because I looked it up, and Velsicol is still around, but it's not like...
Yeah, it's not a major chemical company any longer. Yeah. So they did sort of assuming all this was intentional, maybe it wasn't, but they did an effective job at shielding a lot of the assets of this company. I mean, there were repeated purchases and sales. You know, in the mid-'80s, they sold off what was called the agricultural sort of chemical division of Velsicol. And the people who purchased that, we have been told by the trust, there's a trustee for the site as a result of Fruit of the Loom, who was the ultimate owner, going bankrupt.
Because they had a site down here, or down by...
Well, what it is Fruit of the Loom, there was a company called Northwest Industries that was the owner of Velsicol after 1965, right? And Northwest Industries went through different transitions in what its ownership was. It originally was called the Chicago and Northwestern Railroad, in fact, and then it changed its name to Northwest Industries and sold the railroad in the early 70s. And that's when it took this name. And then Northwest Industries, among other things, owned Fruit of the Loom, the underwear company. And then in a restructuring, that you have to be, I guess, a management expert to understand why these things are good, but in a restructuring in the 80s, Fruit of the Loom became the parent. And
so kind of switched around.
Yeah, they sort of switched everything around, and Velsicol all along had been one part of Northwest Industries, then it was one part of Fruit of the Loom, and then Fruit of the Loom sold off Velsicol, and when it did that, it sold it in two parts. It sold the agricultural chemicals end to a huge Swiss company, Ciba Geigy. They always worked with them. Geigy was the older part of that. Geigy and Velsicol had worked together in the 60s and all this, but then they sold the agricultural chemicals part to them. and then the rest of the company they sold to the managers. So like the guy who ran, because the guy, 7 of the people who ran the company bought the company for Fruit of the Loom, the half that was left over. And that's sort of the part that is what you see when you go out looking for Velsicol today. But even that part then, the reason we got involved with Fruit of the Loom here is the people who, the managers bought that were smart enough to know that they got a lot of contaminated sites they were responsible for. So when they took this Velsicol out of Fruit of the Loom, they wouldn't take the 7 worst contaminated sites. They said Fruit of the Loom had to keep ownership. So Fruit of the Loom then became the owner of the site here. That's why we've been, ever since then, interested in Fruit of the Loom almost as much as Velsicol.
So have you guys made any like direct steps towards trying to hold them accountable? I mean, I understand that that's probably very hard and quite expensive.
Yeah, I mean, the sort of thing that got a lot of attention was in 2000. They went bankrupt in basically New Year's Eve, 1999. And, under the law, when they're bankrupt, they sort of, there's a court overseeing their restructuring and what happens to the assets. And, bankruptcy, essentially, if you successfully go through it, apparently, at the end, the one way you get out is you have a lot of debts and all that. The courts try to apportion out which debt you pay and how much you pay. And the line they usually use is you pay a few cents on every dollar you owe. So if you owed like $1,000 and you're bankrupt, you may pay $100, and then that allows you to get going again. Well, Fruit of the Loom filed for bankruptcy, and the Pine River Group knew that they had this $100,000. We had found out they had this $100 million, rather $100,000. They had $100 million insurance with AIG, and so we filed a claim in federal bankruptcy court for the $100 million. It got a lot of attention because we weren't a normal claimant. Most people who file in bankruptcy court are like, in fact, one of the claimants was something like the California cotton growers who had apparently shipped them cotton and had never been paid. So I mean, that's the normal type claimant. When we entered into it, they said, well, you had no standing. You never sold Fruit of the Loom something and they didn't pay for it. But we kept arguing. We got free legal help from the University of Michigan Law School, and kept filing, and we copied everything to the Justice Department and the EPA and other federal agencies, and eventually they came into the suit, and they're the ones that successfully got a settlement in 2002 that sort of transferred all the property to the government, but then also Fruit of the Loom in the settlement agreed that they would not, they would cooperate in trying to get the insurance money and other assets to pay for the cleanup. And then this has resulted in the AIG litigation, which they think they've reached the settlement. We're not as sure because we think they get more money.
Because
it's a personal view, but I think
it is kind of ending up to be like 1/10 or something, right?
Right. And AIG is a very wealthy insurance company, and we think they ought to pay more. So I'm not sure what's going to happen on that. That's a ongoing issue. Yeah.
All right. Well.